Good afternoon, everyone, and welcome back to the third session of Legal EdCon. This session is entitled Agile Working and L&D, Insights from Other Industries, and I'm joined by a panel of experts, but I won't be guiding you through this session. I'm delighted to say that the Director of UK Programmes at BARBRI, Victoria Cromwell, is. So I'll literally hand over the reins to Victoria. It's all yours.
Thank you, Tom, and good afternoon, everybody. It's a pleasure to be here, and thanks, Legal Cheek, for inviting us all. It's been a fantastic conference, so congratulations. As Tom mentioned, our session today is focusing on agile working and L&D and looking at insights from other industries. And I am joined by a really experienced panel, which I'm really excited to hear their insights and their experiences in this particular field. First of all, I'm joined by Rebecca Chui, who is a former technical consultant at Microsoft. Rebecca is now a commercial associate at Osborne Clarke. Drawing on her years of development experience at Microsoft, Rebecca regularly advises clients within the TMT and consumer-facing sector on a range of commercial issues. So thank you so much, Rebecca, for joining us today. I'm also joined by two American colleagues. The first is Chris Dede. Chris is Timothy E. Worth Professor in Learning Technologies in the Learning, Design, Innovation and Technology program at Harvard University. Chris's research spans emerging technologies for learning, infusing technology into large-scale educational improvement initiatives, developing policies that support educational transformation, and providing leadership in educational innovation. Chris is currently conducting studies to develop and assess learning environments based on virtual worlds, augmented realities, transformed social interaction, and online teacher professional development, all of which I hope we're going to hear a little bit more about later. So thank you so much, Chris, for your time and for being here today.
Thank you for inviting me.
And we're also delighted to be joined by Professor Bill Henderson. Bill is a professor at Indiana University Mora School of Law, an ABA Journal legal rebel, and has been named as one of the most influential people in legal education by the National Law Journal and National Jurist magazine. Bill's a sought-after commentator, so we're delighted to have him here today, on the changing legal marketplace, and his observations and research have been frequently quoted in the New York Times, the Wall Street Journal, and The Economist, to name but a few. And Bill's essays and studies also frequently appear in the National Law Journal and the American Lawyer. So thank you, Bill, and again, thank you to all the panel for joining me today. So, getting on to our discussions, we're going to have a little bit of a chat amongst ourselves on the panel, and then we're going to open the floor to you for questions towards the end. So please, if you have any questions for Rebecca, for Chris, or for Bill, please pop them in the Q&A box. There's also a poll that Legal Cheek have put up for this session, so have a look at that as well. It's clear that agile working is a hot topic, given what we've all been through in the last more than 12 months now, through necessity, obviously, rather than by design. And there's been many press reports of what law firms' approaches and policies are going to be in this regard going forward. So whilst this is a new world for law firms, actually it's something that big tech have been grappling with for some time. So I'd like to start off by asking the panel, what do you think the experience of other progressive industries, what do you think those experiences can do to help firms as they move and sort of flip into this new future that we all find ourselves in? Perhaps I could come to you first, Rebecca, given your Microsoft experience.
Yes, absolutely. You're absolutely right that tech companies around the world have been embracing this for a long time. And I think really the key is not thinking about this in binary terms, either, agile working being just good or just bad. I think in reality, there are great benefits to working flexibly or more remotely, but there are also probably some drawbacks that we probably need to mitigate as well. We've heard a lot about the good stuff. So, better talent retention, more flexibility, save costs on commute, just to name a few. And I think we've also heard a lot of the challenges, like when you have an agile and distributed workforce, ensuring that your colleagues can talk to each other efficiently and get the work done is a different challenge. So for example, if I'm waiting for 8 hours for someone in San Francisco to log on and tell me what to do for the next day, that's probably not ideal, is it? And, how do we ensure that we have those amazing virtual water cooler moments in the office that really can create really great collaboration? And when I think about my time at Microsoft, what tech companies have really learned, I think, is primarily really three things. The first is that I think you really have to embrace an open information kind of structure in your organization so that everything is available to everyone at all times. So we can all sort of work in our own space and our own time without needing to rely on sort of communication in real time. The second thing I think that we've been learning is that companies should really be embracing new technologies. And by that, I mean, using new ways to communicate with each other. Technology's been dealing with the idea of collaboration for a long time, and they're pretty good about it. So it's using screen sharing and virtual whiteboards, even perhaps a virtual Slack room to, imitate water cooler moments. So you can just talk about stuff that's not work related. That can be a really good way of kind of substituting for the in-person kind of benefits. The third things I think we need to do is to be really flexible and mindful, perhaps more than ever, because I think a real common complaint about working sort of agile remotely is that people really expect answers as quickly as they would if they walked up to you in the office. So your day is littered with loads of urgent interruptions. So it's really on us to think about, does my question really need to be answered right now? If not, maybe email is fine. If it's an emergency, instant messages or a call might be warranted. So bearing in mind those sort of new cultural experiences, I think is really important in this new age. So I guess one thing I just want to make clear is that it's not really an all or nothing world. It's about flexibility and finding really what works, striking a balance and mitigating those challenges.
Thanks, Rebecca. Those are some really useful insights. Bill, turning to you as the co-founder of the Institute for the Future of Legal Practice, you've worked with a lot of companies drawing on their experiences and learning from them, particularly, I believe, Google. Do you have any other insights you'd like to share with us to add to what Rebecca's already been talking about?
Well, one thing specifically, I won't point to Google specifically, though. The one thing I would say that's kind of as an adjunct to the agile working environment is sourcing workers, and some of the tech companies have actually jumped over formal credentialing to look for people that are that have revealed themselves through a variety of different mechanisms to be great divergent thinkers and great problem solvers. And I think that that's an approach that we're going to see more and more, because you need people that can actually solve actual problems, and getting a formal credentialing process isn't necessarily a great proxy for it. There's different ways of sourcing talent in the world we're heading into. Second thing is that I think that the most profitable law firms in the world are the ones that have been co-located in one single facility, kind of like the old days of startups, where you'd only fund a startup if all the founders were in one single location. I think that there's ways to do distributed workforce that are world class, but there's something that's difficult to replicate when everybody's in one location, and law firms may be the last to give that up, or at least the most elite ones will be the last to give that up.
Yes, thank you. And I think it's fair to say that, like Rebecca alluded to at the start, the flexibility of a workforce that isn't required necessarily to be constrained to the office opens up the talent pool as well, and it sort of taps into diversity and inclusion goals as well, in terms of bringing in people with different backgrounds who have particular requirements into the profession, which can only obviously be a good thing. Yeah. When we talk about new ways of working and tech in terms of the legal profession, it's more often than not in the context of fee earning, but given our audience today, it's also important to consider it from the perspective of L&D, and to consider better ways of engaging learners in a flexible working pattern into the future. I wanted to talk to you, Chris, particularly about this, because I understand that you've been doing some work around digital puppeteering to help, in particular, for lawyers with the practice of negotiation skills, which sounds absolutely fascinating. Would you like to explain that to us a little bit more?
Yes, happy to do that. So for a long time, we've known the value of simulations in terms of learning. And there's a long history of pilots, for example, using flight simulators to understand how to solve problems when they're confronted with them in terms of airplanes. But although there is a history of simulators to help people learn how to interact with other people, the simulators have been very, very limited because a machine is playing the part of the other person or people that you're interacting with. And machines are very inauthentic in terms of how they can portray people. But now we've reached a point in the evolution of technology where we can do digital puppeteering. So think of the movie, The Wizard of Oz. Digital puppeteering is like The Wizard of Oz on steroids. Instead of one little person behind a curtain controlling some huge wizard, you can have a simulation specialist playing multiple simulated people at the same time. Let me show you a slide that illustrates what this might look like. And this is a slide from a particular company called Mersion. I am an advisor to Mersion, but what I want to talk about is just digital puppeteering generically without tying it to one specific company. So on the left hand in the slide, you see a simulation specialist who has a lot of equipment to enable that person to play multiple human beings as digital avatars. So there's voice morphing, there's tracking of the head and hands so that you can do gestures, there's facial recognition software, there's all sorts of stuff that lets somebody act out a digital person. And on the right-hand side, and this does not mean that they're co-located, the person who's learning could be quite a long distance away. You see someone who's looking into the monitor and they're seeing a virtual setting in which there's one or more digital people that they can interact with. So this is called digital puppeteering, and it has a lot of promise for being as sophisticated in its kinds of simulations. How do you handle different situations with people, as something like a flight simulator has for handling different simulations with airplanes. So to illustrate this, I want to show a brief video. This is one of my colleagues, and he is interacting with a simulated group of students because I'm from a school of education. So here's a look at the video.
Hello class, my name is Mr. Julian. I'll be your substitute teacher for today. We are going to be reading through this.
I like your glasses.
Oh, thank you. Yeah, thank you so much. I just got these a few days ago. So we're going to be reading from this book. So it's a children's book. It's called Never Lonely Again. So one morning, Chestnut stayed in bed longer than usual.
Can you bring it closer? I can't see the pictures.
Oh, I'm sorry. Does this help?
Yes, thank you.
You're welcome. So one morning, Chestnut stayed in bed longer than usual. He didn't feel like getting up. There was nothing for him to do, and worst of all, he had no friends to play with. I might as well keep on sleeping, he thought to himself. Then suddenly the whole house began to move and shake. An earthquake, Chestnut thought, and was wide awake right away.
My mom said there's an earthquake in California this week.
So you get an idea of what this might be like. And a skilled simulation specialist can play 5 or 7 people, different genders, different ages. Each avatar has its own characteristic personality. So there's quite a bit that can be done with this if instead of thinking about helping teachers learn how to work with children, or for that matter, adults, we think about how to help people in the legal profession in situations where they have to work through something with other people. And the specific area in which I've given this some thought is negotiation, which of course is not limited to the legal profession. Harvard held a negotiation and technology workshop last May, a virtual workshop, and one of the technologies presented for simulation beyond the machine-based simulations that we're more familiar with, was this digital puppeteering technology. And some of the students who took a negotiation class attempted to do a negotiation immersion, and some of the faculty who taught negotiation did a simulation immersion. And what may not be apparent from watching the video is two things. First, there's a very rapid suspension of disbelief. I mean, you look at this and you think, well, this is weird. I'm staring into the monitor. There's a bunch of cartoon-like figures. But when it starts, because the human beings are authentic, you're really drawn into it. And you start sweating about a minute into a negotiation because the machine is really pushing you. The script is really pushing you. The other thing about it is that it's very much personalized, because as you could tell when the student complimented Julian on his glasses, the simulation specialist is watching you. They're picking up on all the things that you're doing, and they're improvising within the limits of the script to help you master whatever you want to do. So you're better equipped than I to think about all the ways that something like this might be useful in legal training. Right now, the technology is in its early stage. It takes a simulation specialist and a lot of fancy equipment. I think that the equipment will become less expensive as we move towards scale with this. But even more, I think that we'll get to the point that we don't need simulation specialists. We just need somebody who understands the situation, like negotiation, and who is a good enough at portraying another person that they can do the verbal part of it. Because artificial intelligence, and we'll talk about this more later, artificial intelligence is getting to the point that it can do the nonverbals. So if I'm playing somebody and I'm angry, so my voice tone is angry, my voice pitch and volume are angry, and the content is angry, the machine can figure that out, and it can portray all of the body and facial characteristics associated with being angry. That really makes it easier for somebody to be the simulation specialist. So I think this is a promising frontier in not only legal education, but everything that has to do with skills in interacting with humans. And it will be very interesting to see how this evolves over time.
It's really exciting, Chris, and thank you for sharing that with us and for the slide and for the video clip. It's really good to see what you're describing actually in practice. Rebecca, Bill, any thoughts on digital puppeteering for the future?
I would have loved that. Honestly, you know, you get to practice in a safe environment while feeling this high stakes. I think is a really invaluable experience. Definitely introduce that.
I'm excited about it. It's very very cool, and the stuff that we're doing at the Institute for the Future of Law Practice, that's the kind of technology that we might want to consider using, because it's immensely scalable to teach practical skills. It's not like a lecture, but it's a way to actually embed skills training and make it scalable, and it's much better than the artisan way.
And with the new SQE, we're going to be training our future lawyers in negotiation and advocacy and interviewing, all skills I think that would benefit from this kind of technology. It's really, really interesting and exciting. Thank you, Chris, for sharing that. I wanted to move on and ask Rebecca, based on your experiences at Microsoft, you've undoubtedly got some thoughts on how legal education can do better in certain aspects, but particularly in the delivery of training around the service aspect of legal delivery. What do you think in particular could be improved in the legal education sphere in that regard?
Sure. I'm definitely not a legal education expert, so I'll caveat that. But I think based on my experiences in legal education, there really is rightly there's a focus on getting students learning about the letter of the law and other important skills, like your writing is clear and polished and similarly. And how this translates in law firms is that when we think of service delivery as lawyers, we think about things like how do we write a really good email, how do we be commercial and pragmatic in our advice, how do we quote properly. And while these are really important things, I think we also need to see the work that lawyers do as products, first and foremost. Products where we can think about the user experience and generally take a seriously human-centered approach to legal delivery. And at least tech companies, from my experience, obsess over user experience. You know, if you're making software, you want people to use it, to be joyful and usable, and so you keep using it again and again. And you want to minimize that friction between the user and the software. And I think we can also introduce those principles to legal delivery as well. So, I mean, just to pull a few examples out from my head, let's say in contract reviews, you know, you might be, you know, in a typical law firm, what you might get is a report 60 pages long, reviewing a bunch of contracts. And in my view, I don't think clients really read those. And what we can do is think, actually, what do clients need? Why don't we think of a way that we can maybe present our findings in a way that plugs into this client's system directly, rather than requiring the clients to read it, parse it, and then enter it into their own systems manually, or do what they do with the report. Or what if we used, let's say in drafting contracts, what if we used diagrams, pictures, even videos in contracts instead of walls of text? I feel like that would help us all get on the same page. Just recently, I was looking at a website that did comic book contracts, that allowed people to kind of explain the basics of a contract using really clear diagrams, for example. So I think legal education can really play a pivotal role in helping law students see that as lawyers, they can also be a product manager, a user experience designer too, not just a lawyer, and really consider that entire user journey from end to end, from the moment that you craft that advice to the client, to how the client actually uses that advice. I think that's something that going forward, we're really going to see some real development progress in.
So focus on not just the law, but the client's delivery and the client-centric experience as well. Bill, I wanted to ask your views on this based on your insights from working with firms in iFlip.
Clarke offers some tremendously interesting observations and suggestions. And I was thinking to myself, as a member of a law faculty, every person that gets hired on a law faculty is a substantive law specialist, and they go very deep in their substantive law. And what Rebecca's talking about is kind of a vertical crossover that allows the substantive advice to be delivered more efficiently and more fluidly. And there is no at least right now, a specialization that knits together the substantive law and focuses on higher quality service delivery. And actually, there's nothing about law that makes you good at graphical interfaces or user experience. Those are specialties unto themselves. Like I know people. A good example would be on Legal Evolution, where I curate examples of successful innovation. The legal department at Village MD, which is a sophisticated medical company that drives efficiencies for physician groups, they've got a graphic artist, they've got an ops specialist, they've got a data scientist, plus the lawyer that's basically servicing the legal needs of their stakeholders. And I think the future is going to be of a legal professional that is not just substantively trained here, but might be a graphic artist that serves a legal audience, or might be a data scientist that serves a legal audience. And we're going to take a full generation to fill out that talent scorecard.
Thank you, Bill. Chris, any final thoughts on that?
I think that we see comparable things in education, where you can take a degree in education, you can get certified in education, and it doesn't mean that you really are well prepared to get into a classroom and work with real kids and have a conference with a difficult parent, or have a disagreement with your boss. So I think that we really need to begin with authentic situations in learning, whatever profession we're teaching, and then bring in the expertise when you hit a problem and you don't know how to solve it. And that's when the substantive expertise really becomes useful. So we're kind of theory to practice when we should be practice with just-in-time theory as needed.
I'm just looking at the chat, and we've had some questions and some information about data science. And one of our audience was an electronics and communications engineer before taking the LLB. So a really interesting case in point. Thank you for sharing that. Bill, I want to come back to you and talk a little bit about your online publication, Legal Evolution, which I understand focuses on the changing face of the legal industry. And the theories on legal evolution are very much grounded in the concept of diffusion theory when considering innovation. And I appreciate that the diffusion theory is an enormous topic, but I wondered if you would be happy to explain this concept to us in simple terms, and how firms can, thank you, and how firms can benefit from this particular approach in terms of agile working and L&D.
Well, well, thank you for asking the question. Just what Chris was saying regarding bringing theory just in time to actual practice would be a good idea, because theory is incredibly valuable for problem solving, but practitioners don't want to overlay their practice with a bunch of complex theories. They want it to be simple and usable. So diffusion theory is the second most cited theory in all the social sciences. This comes from a book by a guy named Everett Rogers. That was, the first edition was published in 1962. He was a rural sociologist, and he published 5 editions of his book, between 1962 and 2003. And here's the basic idea of diffusion theory. It's a generalizable theory for how innovations get adopted. And basically, an innovator sees a problem in a better way of doing it, brings some sort of new technology, new know-how to actually solve it. They're kind of in Edison's-like laboratory, constantly looking for new and better ways of doing things, and they're that way by disposition, so that their mindset is on novelty, on science, on evidence, and they generally pitch their ideas to early adopters that are very commercially ambitious and want to be successful. And innovators and early adopters work together to basically bring things that are actually workable, that are actually commercially viable. And so imagine what this is a technical term from diffusion theory, a social system, which is a big bell curve. And you have your innovators, which are about 2 standard deviations from the mean. There's not that many innovators, 3 innovators. They're working with early adopters, which are 1 standard deviation from the mean in terms of their openness toward innovation. They get some sort of success going, and then the early majority, which is the next to the social system, copy basically what's working for the early adopters. The late majority copy what's working for the early majority, and then finally there's the laggards that are basically just letting go of the old technology. They probably still have cable TV. They probably still have rotary phones, and so, but by disposition, they're very, very conservative and reluctant to let go of things. But there's ways to, once you understand diffusion theory, there's actually levers you can pull to speed up the adoption of innovation, particularly identifying who you're talking to. Am I talking to an early adopter if I'm pitching a new product? If I'm talking to somebody in the late majority, I'm wasting my time. It's a way to solve. That's how I became aware of it. I had a legal tech startup company, and I was trying to solve my sales cycle problem. And I went, like Chris was pointing out, I went to a theory to solve this, and diffusion theory was the right theory at the right time. And so when we sold the company, when I was coming back to writing full-time and researching full-time, I wanted to bring this very practical applied research theory to the legal industry, because we really, really need it, because we're dealing with very complicated use cases, and we need diffusion theory to speed up the adoption of these innovations.
That's really fascinating. I mean, I think lawyers and law firms are sort of notoriously risk averse, and so we probably have the spectrum of those approaches represented by our legal profession in the UK. But we're also very lucky in the UK to have, at the moment, loads of legal innovation going on. So hopefully that's going to diffuse even further as time goes on. Chris, you must be aware of diffusion theory and the concepts that Bill's been talking about.
I am, and I agree it's incredibly useful. One of the other aspects of diffusion theory is that they have tools like social network analysis to identify what's called influentials. Yes. And influentials are people who not necessarily, it doesn't reflect how much power they have. It doesn't reflect a particular title that they have. They're just people that, by their very nature, are widely respected by other people. And if you know, if Annie is doing this, then I know it's worth trying. That's the kind of thing that someone would say about an influential. Influentials are about 3% of the population, but what diffusion theory recommends is that you focus about 50% of your resources on that 3%, because if you get them, then other people will follow.
Yes, we sometimes call them opinion leaders. That's what on a legal level we call them opinion leaders. But Chris, it's a perfectly influencers, or it's a very literal way of putting it.
Chris, if I could stick with you, if I may, we discussed your digital puppeteering, and that with your work, you've argued that this concept of immersion in a digital environment actually can enhance education, because you can allow these multiple perspectives and reality simulation. So as law moves to agile working, do you think that tech has a part to play in CPD and continuing professional development and improving how fee earners are actually providing their legal advice?
One of the areas I work in is the evolution of artificial intelligence, what that means for human beings. And a concept that I want to introduce is called intelligence augmentation, IA, rather than AI. So people are worried that as AI advances, it's going to eliminate jobs, and it will eliminate a small proportion of jobs. But for many more jobs, the job won't disappear, but the machine will start to do parts of the job. So for example, I'm working with an AI specialist who develops different kinds of automated teaching assistants that can answer questions, or that can help students in the library, or that can run a laboratory, or that can help students find social connections within the class. Now, the good news is that that takes those burdens off of me, and potentially I can do the human part of the job much more deeply, because I've freed up from some of the simpler stuff. The bad news is, if I don't have the capability to go ahead and do those more deeply human things, if all that I really know how to do is the simple stuff that AI takes over, then I'm de-skilled rather than upskilled. One way to understand this, if you are familiar at all with the Next Generation Star Trek, is to think about Data the android and Captain Picard, who is the human side of the partnership, the starship captain. Data is really good at what we call reckoning. And reckoning involves very rapid calculation of formulaic kinds of things. So Data can make all kinds of predictions. He can pull up any piece of information from a huge database instantly. But Picard's side of the partnership is judgment. And that involves human understandings that machines cannot attain, understandings of culture, understandings of human emotion, understandings of what it's like to have a body and to have embodied experiences in the world. So a really effective intelligence augmentation is when the human being lets go of the reckoning, because it lets them go deeper on judgment. Now, we're not doing a good job of recognizing this in education, that this is where not only work, but many aspects of life are going. So for example, Harvard's admissions policies, the SAT, the ACT, the GRE, we've got the LSAT in the United States. That's reckoning. That's what the machines do well. So we're preparing human beings to lose to artificial intelligence. And what I see in the future of legal practice and other professions is that a lot of the reckoning parts of it, and I think, Bill, you referred to that earlier when you talked about the fact that people don't need to master all of these processes, many of which are formulaic and which AI is going to do. What they need to do is understand how to solve problems. So I'm not a lawyer, but imagine that somebody is in a medical malpractice situation, and the lawyer's advice is to go ahead and sue, but the client is someone from a culture where suing the government is something that they're very reluctant to do. So there's a cultural dimension to it. The client has financial issues, and so there's risks involved in suing rather than settling. The AI can give you all sorts of estimates about the risks, but the human being, the attorney, is the one that has to have the judgment. So that's one way to think about where things are going, is that every year, more and more of the reckoning is going to shift and become, therefore, less useful to the person, and more of the judgment is going to become paramount.
I'm delighted that we've managed to get Wizard of Oz and Star Trek into this panel, Chris. Thank you for your insights on that. And you mentioned what Bill had spoken about earlier, and I wanted to just see if Rebecca and or Bill had anything to add to what Chris has just been discussing. I think Bill's trying to get off mute.
Well said, Chris. I really appreciate your insights. The more the current post on legal evolutions by my friend Dan Carell, who's the headline says it all here. The AI rocket ship will be manned, you know, and it's going to require our most human capabilities. And so, ironically, the more machine dependent we become, the more our value add is going to be our capacity for human interaction and empathy, and things that machines just can't do. As you said, they're inauthentic. So.
Thanks, Bill. So we talked a little bit during the course of this panel session about big tech. And as we all are very much aware, big tech is run differently to law firms who adopt the more common partnership model. I wanted to ask all the panel, what aspects of running a business, for example, perhaps around work allocation, could law firms learn from big tech, but also from other progressive industries?
Yeah, sure. I guess from my perspective, I think law firms are really complicated businesses. And a partner who has his or her hands can be often quite full with BD client work and won't necessarily have the bandwidth to kind of think about process improvement or more day-to-day tasks such as resource allocation, as you mentioned. Back when I was a consultant, it was actually quite similar to being a lawyer in some ways, because we were billed on time and materials basis and involved, quoting and scoping for work in this very similar way. And back then, my job was really purely just to make the product. And we had people who were dedicated product managers, people who were project managers or people managers, or people who also did all this resourcing of the projects. And when I ask my friends about how their law firms work, I'm really surprised, I guess, about how so much of the day-to-day business management is done by lawyers. Resource allocation, as you mentioned, is really one of them. And really one of the great challenges in a law firm is managing capacity and ensuring the right work goes to the right people. Because if you do it wrong, you can overload your people or staff. It could mean that only certain people get certain types of work. So people aren't developing. So it's actually a really big deal. And so I think it's a real ongoing problem, and it's a complex problem, and it's on how to get this right. I think partners might not have the time, to think about it. So I think some law firms are thinking about resource allocation projects, but as far as I could tell, it's actually mostly work in progress for most law firms. So I think we'll see some development in the future about how we might outsource that work differently in the future.
Definitely. Thanks, Rebecca. It's interesting to hear your insights. And I think one of the things I've noticed in recent years is the rise in dedicated project managers in firms. It's a particular job title, and that these are people who aren't necessarily from a legal background, but have a better handle on such things than perhaps lawyers do. Bill or Chris, did you want to jump in on that at all?
I have lots of thoughts on this, and a recurring theme on legal evolution is how the unbelievably great hand that law firms have to productize legal solutions. They've got lots of they've got existing customers, they've got a trusted a brand, they've got access to users, and so but they're slow to go down this road. And part of it, there's a couple of different reasons. One of them is that they're really in the business up until now of selling expertise by the hour, ideally at the most premium rates, and they're worried about cannibalizing parts of that. And also, when you're in the business of selling your judgment by the hour, to turn that off and begin to think about productizing parts of what you're doing, there's no reward structure for doing that. And third is, and there's a lot of money to be made if you can take a part of your expertise and externalize it. But they worry about conflicts. And so what you want to do is take the insights that are available in the law firm and scale them to a very broad latent market that can't afford your services by the hour, but would love to avail themselves of the productized solutions that you're uniquely qualified to develop. And so it's going to take a full generation to sort out the cultural issues of because there's many law firm associates that like the person that we heard from that's got a CS background, that they'll go into a law firm and they'll do like, I'm doing work that can be automated. Why am I doing this? And they're going to get frustrated. But over the next generation, I think we're going to see some law firms basically become technology companies, and a large stream of the revenue is going to come, but they're going to have to sort out a lot of business model issues. So it's a complicated, it's one of the most complex organisms that I think about on a frequent basis. It's just, it'll take a full generation to sort.
That is music to my ears to hear that you think that. But quite honestly, I think you're right. When I think about law firms, they're always going on about AI. We talked about AI quite a lot, but really law firms are, as you know, bundles of data mess. They have unstructured data. They don't know how to sort it. They don't know how to deal with it. There's not a lot of metadata. So really, we're actually quite far, I think, from really using AI in a way that's really going to be helpful in the legal industry, at least from my view anyway. But once we get that, once people are actually being smart with how they do their work and properly sort their data out so it's really structured so that we can label it, so we can use it in AI technology, I think we're going to go much further down.
So some complicated things to work through, but exciting times ahead, I think, is the general message from that. I'm conscious of time. We've just got slightly over 10 minutes till this session comes to an end. So I'd like to turn to some of the many questions we've had from our audience panel, if I may. So starting off, as a question that asks, does the panel believe that law firms' clients will encourage agile working to drive down costs and save the planet?
Absolutely. Yeah. I think we've seen that it works. Agile working works. If not, we're working just as hard, or if not more than we were before the pandemic. So I think the question is it's proof that it works. And why do you need expensive central London office, while we're paying for those overheads? And I think also clients like to see, when we preach about being modern law firms, really cutting edge technology, when we're advising on cutting edge technology issues, they'll also want to see that we're walking the walk so that we know what we're doing. So I think for us, we need to adopt what our clients are doing. And if our clients are also working on an agile basis, then I think it makes sense for law firms to feel encouraged to do the same.
Yeah, absolutely agree with that, Rebecca. Thank you. Naya Bari has asked us, are there specific aspects of technology law firms should be adapting in order to make the move towards agile working more efficient?
I don't have to speak.
Data science was a theme that came up earlier in the chat, and that Rebecca referenced the challenges with organizing data. Artificial intelligence is completely dependent on the data that's fed into it, and if you put garbage in, you will definitely get garbage out. So the whole key, I think, is understanding how to organize the data so the technology can help you make sense of it, but then also how to have human beings understand the data, so if the technology is giving some kind of dysfunctional answer, the person can recognize that and try to figure out what's going wrong.
Thank you. Turning to a question from SHM. The question is about user experience and what's being done at the moment to improve that in an increasingly virtually delivered legal education market for students. Neurodiverse students especially could benefit from more accessibly designed platforms and frictionless formats when encountering their studies. Well, from BARBRI's perspective, we have deep investment in our learning technology and our learning platforms. So we're very confident that the user experience reflects an environment that has been built from the ground up with the virtual experience at the heart of it as part of our blended learning courses. But if the panel have any other insights into that, I'd be very interested to hear them.
Well, the book that I co-edited in 2019 is called Learning Engineering. But what that really is engineering learning. And we now can collect such rich data from online platforms, and we now can modify instruction on the fly so that we can do little micro experiments in which one group of people is taught using one variant of instruction, another group is taught using another variant. You see what works when for who. You adjust the instruction accordingly. We're moving towards the ability to truly personalize learning. And I don't just mean adaptive learning, where you figure out what somebody needs to know and give them only that. I mean true personalization in which learners themselves have a choice about how they learn, and to some extent what they learn and what medium they're learning in. And the real key, I think, to unlocking puzzles of neurodiversity, puzzles of bias, puzzles of bringing marginalized and underrepresented groups into full realization of their potential is this ability to use data to personalize.
Bill, have you come across in your work any particular insights from industries into what's being done to adapt or to enhance the experience for neurodiverse individuals?
For diverse individuals in particular, I can say that we see more and more demand from legal employers and clients to make sure that there's a more diverse workplace, and I do think there's a connection here with learning platforms, because one of the things that we learned when we opened the Institute for the Future of Law Practice, it was the idea of using it as a bridge to bring what we call T-shaped top of the T. Here's legal is the bottom of the T, but there's data, process, technology, design, and business operations things. We were looking for scalable ways for teaching that, and we started with some boot camps that brought in people from a variety of different schools. And one of the things that we were shocked to find out is that we got a much more diverse student body than you can typically get into ABA accredited law school. 65% of our applicants were female, over 50% were diverse. We ran them through behavioral interviews. They did remarkably well, so our student bodies were diverse, and employers were really floored by this, and they thought that not only are your students better trained, but they're exactly the modal students that we want. And one of the things that we hope to do with iFlip is to use the learning technologies, the engineered learning that Chris is talking about, and make it available at a very low per unit cost to law students and eventually even paralegals, so that it can be a great learning experience, and eventually will bubble up into the broader university. But that's not going to happen. We need to start with micro credentialing and just teaching things like maybe the equivalent of 2 hours of design theory, so that that can be done through a learning platform. And I think everybody will benefit once we go down that road here. And it does open it up to everybody. And so there's a lot less elitism with these learning platforms. As a matter of fact, there's a leveling. So I'm very excited about the potential here.
It sounds great. And the work that you're doing both at the in future of legal practice and on legal evolution is fascinating. I'm going to put a link to both of Bill's websites with his permission in chat. And I'm also going to link Chris's academic paper on artificial intelligence and technology in teaching negotiation, because I think there's going to be people who are interested in finding out more about that. We are coming to the end of our session, and I think I have dealt with all the Q&A. Oh, we've got one more that's just come in. Bill, could you drop the name of the 1962 book that you mentioned into the chat, if you wouldn't mind, or tell us?
It's Diffusion of Innovations, and so you want the 5th edition as opposed to the 1st edition, because the 5th edition is chocked with a lot more examples. This is from 2003. It's the 2nd most cited book in all of the social sciences. It's applied research, and so it's about solving practical problems, rather than than theory, pure theory.
I think there was one more question just while we were discussing that. One for you, Chris. You mentioned that technology can be utilised to free up teaching time for higher value learning. How does this play out in law school?
In law school, there are as any kind of professional preparation, there are what we might consider to be frequently asked questions, and by developing teaching assistants that are capable of answering those frequently asked questions, it frees up the faculty member to deal with questions that are deeper, that really require a more complicated answer, an answer that might be personalized to a particular individual. So that's just one example of this approach. But I do want to say something about technology, because I've talked about different technologies in this, and I don't want you to leave with a misconception. Technology is never the innovation. It's always the catalyst, but it's never the innovation. Learning technologies are not like fire. Fire is wonderful because just by standing near it, you get a benefit from it. But you can be a teacher who uses an enormous amount of technology, and if it's not used well, it's just going to automate bad teaching and take it to a higher level of scale. So it's always a matter of starting with deeper content, more active forms of learning, more authentic forms of assessment, links between the classroom and life. If technology can help with that, well and good. If it can't, then don't invest in it, would be my advice.
That's really, really good advice, and it very much mirrors what we're doing with our SQE prep courses, moving away from, like you mentioned in the article we wrote together, Chris, it's the tell and listen method versus collaboration and doing, and a much more user immersed experience in terms of legal education. Thank you so much. We are a couple of minutes off the keynote from Julie, and so I think now is probably the time to say thank you so much to Rebecca, to Chris, and to Bill for all your really fascinating insights and your time today. We're deeply appreciative, and I hope you all enjoyed the session. Thank you.